my lady, then to Dingle on the point about other publications, the extent to which they can properly be relied upon in this case. So I say the judge relied upon them in paragraph 8311. The rule in Dingle is set out in the skeleton arguments and is familiar. It rules out reliance and mitigation of damage on publications to the same effect as those relied upon in the proceedings. It's of high authority and endorsed recently by the Supreme Court in the show. There's an established exception to the rule in Dingle, provided for by the case of Goody and Oddham's Press. This provides that a defendant can rely in mitigation of damage on a claimant's previous convictions and the publicity given to them, because they are the best guide to the reputation which the claimant both ought to have and does have. In my submission, the other publications which are relied upon by the judge are ruled out by the rule in Dingle and can only properly be admitted in evidence if they come within the Goody exception.
Are ruled out from what?
Sorry, they're ruled out by the rule in Dingle because
they're ruled out from...
Oh, sorry. From consideration of the issue as to whether the claimant has no sufficient reputation left such that it would be an abuse for him to seek to vindicate that reputation in this court. Essentially, the point is that his reputation is so destroyed by the publicity given to the conviction that it would be an abuse, disproportionate abuse for him to seek vindication. I say the other publications don't come within the exception to the rule in Dingle for two reasons. Firstly, a foreign conviction cannot properly be seen as a guide to the character of an individual, i.e. the reputation he ought to have, because the status of foreign convictions in English law is simply as an expression of the opinion of the foreign court. And that follows from Hollington and Hewthorne. And secondly, I say that a foreign conviction is not necessarily a good guide to the actual reputation of a claimant in the eyes of others, because foreign convictions are not necessarily regarded as reliable in the eyes of the ordinary reader in the way that English convictions can be regarded as reliable. That point is similar to and has echoes to the point I was making in Hunter. Lady, having set out the argument, I'll then go to the case of King, which is relied upon against me on this point. It's in bundle 4, tab 35, and I begin at page 1006, hard copy, 1007 electronic. Another case of my ladies faced with an abusive litigant in person. Paragraph 3, the lady who set out the claimant was a former English barrister, convicted by jury trial in New Zealand after a 7-week trial of 2 offences. Then in paragraph 4, he was sentenced to 7 years imprisonment. His appeal against conviction sentence was rejected by the New Zealand Court of Appeal. Over the page, please, to the end of 1007, Court of Appeal upheld the maximum sentence on the conspiracy charge. Doing so, the Court of Appeal stated the judge was entitled to regard the claimant's action in this case as being of the most serious end of offending of this nature. Paragraph 7, I will not set it out. The decision of the court should obviously be read in full. He noted the claimant represented by counsel, and that the analysis of that court was, as might be expected, very thorough, and though not uncritical of certain aspects of the trial judge's summing up.
Yes, to be noted also on the previous page, that as was recorded by the Court of Appeal, because this document was put in by the claimant, that there was no dispute. It says that the claimant didn't deny he'd been involved in the construction of the buried box or the primary facts, and the only dispute was as to intent. His case being this was going to be a game of kidnapping, not real kidnapping.
Lady, yes, I rely on that, and you find there were three bases on which the application was made to get rid of the claim. One was that the allegations were plainly true, and that was one of the bases on which it was struck out, independently of the conviction, because of the admissions given by the claimant, made by the claimant. Well, we can see from paragraph 9 that not only was he convicted by the New Zealand court, but then a disciplinary tribunal, the Council of the Inns of Court, expelled him from the Middle Temple. Paragraph 12, the Privy Council refused him leave to appeal. 13, all these matters, that is the claimant's conviction, his sentence, his expulsion from the English bar, were widely reported in this jurisdiction. Then to paragraph 17, please. The fact the claimant was disbarred was also reported in this jurisdiction. Paragraph 20 states there were two publications complained of in the action. One was an email sent to a solicitor. And paragraph 22, the second was an item published on the amazon.co.uk website as a review of the website's listing for the claimant's self-published book. Then paragraph 24 sets out the issues in the case. The defendant applied to strike out on 3 grounds. That the litigation was a Jamil abuse, the statements were substantially true, and the publication was made on an occasion of absolute privilege. All 3 were successful. Then the abuse application is considered under 25. And I take you along to paragraph 32, please, which is where the Dingle issues arise. For present purposes, it is also relevant to observe a long-established foundation of the law of defamation that it will not permit a man to recover damages in respect of an injury to a character which he does not or ought not to possess. Burston and Daniels. In this context, regard has to be had to the effect of previous convictions on a person's reputation. Previous convictions within the general sphere of a claimant's reputation are admissible as evidence of general bad reputation. They're the raw material on which bad reputation is established. They're the best guide for a claimant's reputation and standing. And that's a quote from Lord Denning in Goody, where the exception derives from. I don't need paragraph 34. And then paragraph 35 to 38, Milady, you said, in my judgment, this is a paradigm example of a claim to which the principles of Jamil abuse apply. It's fanciful to suppose, in light of the facts to which I've referred, claimant's conviction in New Zealand, his subsequent disbarment, that's of course English disbarment, and the reports that those gave rise to, the claimant has a reputation in the relevant sector of his life which is capable of being vindicated by his proceedings. Then you refer to the decision in Williams, which was similar points both were made, but in relation to an English conviction. And then paragraph 38 is the key paragraph for this issue. It reads, it's true the defendant cannot rely upon the claimant's convictions in New Zealand as conclusive proof, pursuant to section 13 of the CEA, that the allegation is true. Nevertheless, the court, in my opinion, is entitled to have regard to the findings of a court of competent jurisdiction on an application of this nature, a view that I've already expressed in El Douani. In my view, section 13 plainly does not operate to prevent a defendant from relying on a conviction in a different jurisdiction as evidence of bad reputation. In particular, where, as here, it relates directly to the relevant sector of the claimant's reputation, is not spent and is notorious. So to my submissions on that, my lady, my lords, it's plainly correct that Section 13 does not prevent a defendant from relying upon a conviction. That's not what it says. However, in my submission, it does prevent a defendant relying upon a conviction, foreign conviction in mitigation of damage, as to the reputation the defendant ought to have, the claimant ought to have, because that's barred by Hollington and Hewthorne, the opinion which makes the conviction simply the opinion of the foreign court. Now, that's not a problem in this case for the reason which my lady gave a few moments ago, that the court independently found that the claimant was guilty of the allegations made in the criminal proceedings. And that was the same in El Dawani, where there was independent finding that the claimant was guilty. So the court was proceeding on the basis that the claimant didn't have, or not to have had, the character which he was seeking to vindicate. The second point from this paragraph is the importance of the final two words. The conviction which is not spent and is notorious. This recognises my submission that it's not the conviction itself which generates a general bad reputation, but the publicity given to it. In this case of King, there's no suggestion that the publicity given to the New Zealand conviction was accompanied by any information which would have given any reason to doubt its safety or the independence of the tribunal. Which is why I'm going to come shortly to the evidence in our case. So the key phrase, perhaps, is in the third line. Nonetheless, the court, in my opinion, is entitled to have regard to the findings of a court of competent jurisdiction application of this nature, by which must be meant a foreign court. Now, for the reasons I've given, with due respect and diffidence, I say that's wrong if it's meant to extend the Goody exception to foreign convictions generally, in the way that it applies to English convictions. But if all that is meant, that the court is not, as a matter of principle, necessarily debarred from assessing whether a foreign conviction can be taken into account on the question of what reputation the claimant has, then I don't need to take issue with it because of the evidence in this case. Both El Dawani and King are good examples of why a sort of flexible test like that works in those two cases and didn't work in this. Mr. El Dawani was convicted in a convention state. He had full opportunity to appear at his trial. He was able to appeal all the way to the Strasbourg court. And those are matters which would command respect in the eyes of the ordinary English reader. The English reader would think worse of Mr. El Dawani, knowing those facts about the Norwegian conviction. And there's no
circumstances where he'd made admissions.
I did. Yes.
And the convictions were based on recordings which were available to the court in Norway and were part of which were played before me.
Yes. And there was no reason to suppose that the publicity in relation to those convictions, which there had been, carried with it any reason to doubt their reliability or the independence of the tribunal which had come to those decisions. And similarly in King, in this case, he was convicted in a Commonwealth state, operating under the common law. He was able to conduct his defence without any impediment, take advantage of appeal to the New Zealand Court of Appeal and then to the Privy Council. Again, all matters which would command respect to an English audience. And again, the extensive publicity which was given to his conviction and his English disbarment. There's no suggestion in the evidence that it gave any reason to doubt the safety of that. So, I want then to contrast this case. which is that on the facts, however far the Goody exception extends to foreign convictions, it just can't work when one sees the publicity in relation to the Bangladeshi tribunal in this country and the claimant's conviction. There are some examples in the claimant's first witness statement of pre-publicity before the conviction, which recorded the concerns about the reliability of the tribunal. Supplemental bundle, page S37, beginning at paragraph 61. Sorry, going to the witness statement has just reminded me of one point I ought to have corrected from this morning. The claimant came to the UK in 1973, not 1971. So paragraph 61, by May 2013, that's long before my trial in absentia, both politicians, NGOs and leading legal and human rights commentators throughout the world had expressed serious misgivings about the ICT process. And a number of examples are given here, from British parliamentarians, US war crimes ambassador, and human rights organisations. Perhaps I can just give bundle references to these paragraphs because they're not in the witness statement. Paragraph 63, which is the parliamentarians, the reference is S110, S110. Paragraph 64, the US war crimes ambassador, bundle reference S99. Paragraph 65, criticisms by the United Nations Special Rapporteur, S152. 65, criticisms by Human Rights Watch and Amnesty International, S97. The Economist publication and the Wall Street Journal publications, The Economist is at S139, this is on paragraph 67, and the Wall Street Journal is S144, both of which reported on leaked Skype recordings between a sitting judge of the tribunal and a lawyer in Belgium, I think it was, which amongst other things has the judge describing the claimant as an extreme and crooked type of person, a bad person, in October 2012. You'll see that at paragraph 70. So serious, widespread, high-level concerns about the partiality of the tribunal in the public domain before the conviction. Then two examples of the publicity which accompanied the conviction. I've given a number of those examples at paragraph 67 of my skeleton argument. I want to take you to two in the file, please. The first is a Reuters report on which it appears much of the other coverage was based, page S170. Reuters, November 3rd, 2013, 2 death sentences in absentia for war crimes in Bangladesh. And passages I draw your attention to are 5 paragraphs down. Lawyers representing Mueen denounced the verdict and said the court had staged a show trial. Over the page, the second paragraph. The Prime Minister's opponents say she's using the tribunal against the 2 biggest opposition parties. 3 paragraphs down, the New York-based Human Rights Watch group has said the tribunal's procedures fall short of international standards. Rejecting all charges levelled against Mueen, the international legal team said in a statement, "This is coming from a body that's been accused of gross irregularity and misconduct by human rights groups, notable figures and institutions around the world. It accused the government of staging a political show trial, called for a halt to all trials, convening of a full international inquiry. One other example, perhaps, a shorter Daily Telegraph report at S160. And I draw your attention to the final two paragraphs in S161. Mr. Mueen-Uddin's lawyers protested his innocence, claiming he'd been convicted in a political show trial. And then his counsel, Toby Cadman, said, "I'm not at all surprised by the verdict's been passed today by an institution that has lost all credibility. We reject each and every charge levelled against Mr. Mueen-Uddin. It's coming from a body that's been accused of gross irregularity and misconduct by human rights groups, notable figures and institutions around the world." The final illustration I want to make of this point, my lady, my lords, is in reference to the article which was, the link to which was given in the words complained of. You remember there was a link to a Channel 4 broadcast from 2013. The argument which was advanced on the meaning hearing before Mrs. Justice Tipples was that the ordinary reasonable reader would have clicked through, well, the ordinary reasonable reader of the online report in any event would have clicked through and watched the Channel 4 broadcast. And in those circumstances, the argument was advanced that the broadcast contained so much of an antidote to the allegation made by the War Crimes Tribunal that the report, when read with the broadcast, was not defamatory at all. One can see the meaning which was advanced on behalf of the Home Secretary in Mrs. Justice Tipples' judgment at S58. So it begins at S58, and the meaning advanced is at S60. Defendant's position is that the words complained of in their proper context by the following ordinary natural meaning. Claimant was found guilty by Bangladesh War Crimes Tribunal following a trial in absentia, crimes against humanity, but the claimant strongly denies responsibility for such crimes. There are serious doubts about the fairness of the trial, the legitimacy of the tribunal, and the safety of the conviction, resulting from numerous allegations of witness abduction, coercion, falsification of evidence. The defendant maintains that this meaning is not defamatory at common law. My lady, my lords, the transcript of that programme was before Mrs. Justice Tipples, but it's not in the file. We have copies here. I'll hand them up at the appropriate moment. I'm not proposing to take you to them. But
where are we on the argument that you're advancing in this appeal? What are we
lady, we're at this,
considering at the moment?
Sorry, we're at this point that if I'm wrong that the publicity in relation to the tribunal conviction is not admissible, then when you look at the publicity about the tribunal conviction, it doesn't destroy the claimant's reputation in the way that publicity about an English conviction would. And therefore, he has a subsisting reputation which he can properly seek to vindicate in these proceedings. And the respondent's goody argument, as I understand it, is that the publicity which accompanied the verdict so destroyed his reputation that it was pointless litigating about it anymore. So that's why it's in the Jamil abuse category. Nothing worthwhile to gain because the reputation was already destroyed by the conviction. The respondent doesn't rely upon any evidence for that. Ordinarily, if you're trying to prove that someone has a bad reputation, you call evidence from someone who knows them. And all the respondent relies upon is the publicity in relation to the 2013 conviction. And that was what the judge relied paragraph 83(12) of his reasons. And I say it's simply unsustainable on the facts. And the appellant has put evidence before the court that his reputation was not destroyed by the conviction. Paragraph 73 of his witness statement. Page S40. Paragraph 74, he says he felt obliged to offer his resignation to a number of the charitable organisations he was involved in after being convicted. However, many of these organisations were reluctant to accept my resignation. Two organisations refused to. They considered it was my civic duty to remain on board. They made it clear to me they did not believe the allegations. 76, I continued to be made welcome by local mosque and other community groups in a way which would simply have not been inconceivable had my reputation been that of a war criminal. If the conviction had been in the UK, or it had been in Norway or New Zealand, it's simply inconceivable that he could have continued at his charitable organisations and being welcomed at the mosque and the other community groups. So, ladies, seen in context, what the evidence shows is that the damage caused by the publication of the allegations of war crimes cannot sustainably be said to have caused only trivial damage. Claimant still had a reputation to defend. And that reputation was very seriously damaged by an allegation that he was a war criminal, published with the imprimatur of the British Home Office on the official website of the Commission for Countering Extremism. I mean, I accept, of course, this is not publication in a national newspaper, but the evidence is that publication was substantial, over 5,000 copies, and before one even accounts for the grapevine effect of the allegations going further than their original publishees. And I accept, of course, the allegation is not particularly prominent in the report, but this is a serious report into extremism. It'll be read by those who are interested in what extremism looks like in England and Wales. It's an audience which is likely to have paid careful attention to the footnotes, and an audience which will have taken real account of what the British government is saying. There being no suggestion in the report at all that there should be any reason to doubt the reliability of the conviction or the independence of the tribunal. In those circumstances, my lady, my lords, I do not shrink from the submission that the judge's view that this was a Jamil abuse was plainly wrong.
If you say that his reputation prior to the publication complained of was as somebody who had been convicted by a tribunal which was open to serious international criticism, and that he did not take part and he denied his liability. But then the British government had asserted that he was guilty of war crimes. You might say that he had a particularly strong interest in vindicating his reputation in that regard, because the British government had plumped for one of the two versions which were out there as part of his overall reputation.
Lord, yes, quite. The source of allegations is an important factor generally when considering the harm caused by them. trivial story in a tabloid about a celebrity may be not taken much account of by a reader. But this is, as I say, a serious allegation, a serious report by the government. And that's an important matter to take into account as to whether vindication is something which he can properly come before the court to seek.
Can I just ask a couple of questions about your submissions on Dingle, if that's all right? First, it's obvious from about 1971 there have been newspaper reports suggesting that the appellant was involved with the underlying allegations. What do you say that status is in relation to Dingle and his reputation?
Well, those publications are not, as I understand it, relied upon for the reason that they're not reports of a conviction. The 1971 local news article, the Daily Purbadesh, I think it was, which is relied upon by the tribunal. No evidence that was ever published in the UK. It's published in a foreign language. Even if it were admissible in my submission, it would have no effect on the claimant's reputation in 2019.
Secondly, sorry.
No,
yeah, I thought you finished.
I have.
Secondly, in paragraph 15 of his witness statement, one of your claims is obviously in relation to membership of JEI on the data protection. He says that it was widely understood or misunderstood that ICS was the student wing of JEI. Where does that feature in relation to the issue of whether that can be taken into account in whether this is abusive for the purposes of the Data Protection Act? Okay.
Well, the complaint is no longer made in the data protection proceedings that that piece of data was inaccurate. Its item of data
because it was set out in the judgment by Mrs. Justice Dingemans.
Yes. I think one can take it from the judge's judgment. I'm not sure the judge says it, but paragraph 28(1) is the personal data contained in the report, concluded by Mr. Justice Tipples. By the time of the hearing before Sir Andrew, there was no longer a complaint that 28(1) was inaccurate.
Right, okay, that's very helpful. And then the third question was, you talked about the publications post-conviction. I mean, one of the starkest was the Independent S168, the supplementary bundle. I mean, were proceedings brought against that, and does that feature at all in whether it's an abuse to come back sort of 10 years later against the government?
Proceedings weren't brought against that, my lord.
Because with the repetition rule, I mean, the meaning of that would have been that he was guilty of war crimes.
There may well have been a defence of reporting privilege to this article. I haven't analysed it for those purposes, but one of the innovations in the 2013 Defamation Act is that contemporaneous reports of court proceedings anywhere in the world are protected by the reporting privilege if they are published for the public benefit. Now, it was originally alleged, or maintained by the respondent, that the report itself was benefited from that privilege. That's not a defence which is before the court today. We'd say the report clearly adopts the allegation by saying that the claimant provided a link between those responsible for the violence in 1971 and community leadership in East London today. So in my submission, it sits there, a privileged report. I accept, and I don't think I submitted otherwise, that not all of the publicity in relation to the conviction included the claimant's denials or his response. So yes, it's been pointed out to me, my lord, that this in fact does include that response.
It does include his denial, but in a newspaper report which, with the repetition, would mean that he was a war criminal.
My lord, yes, but probably privileged.
Yeah. Okay, well that's very helpful. Thank you very much.
My lady, I'll make the data protection point very quickly, if I may. I'm over my time already. Unless I can help anyone further on Jamil.
No, thank you.
My lady, the ground of appeal is that the determination of the claims under Article 6 and Article 10 of the GDPR does not depend on whether the data is accurate or not. It's simply an irrelevant issue, and therefore neither the Hunter nor Jamil abuse points arise. There is no defence, and the respondent's argument is in fact quite difficult to analyse in the absence of a pleaded defence. There are various assertions in evidence and in submissions about what is likely to be pleaded and why that would bring the issue of accuracy to the fore. But I do submit that at this stage the court should be entitled to a defence so that it can analyse the issues properly. It can be decided whether any plea of accuracy should be struck out as irrelevant on an informed basis. My other general submission is that there is a repeated assertion in the respondent's skeleton argument that the balance between the ECHR Articles 8 and 10 cannot properly be conducted without determining whether the data is accurate. That, in my submission, must founder for the same reason as I sketched out in relation to Jamil, namely the respondent has no Article 10 rights. The judge found that the claim in relation to Article 6 of the GDPR, I can take you to the pleading, please. Tab 9 of the core bundle. Page C98. The pleaded case, the claimant's pleaded case, necessarily raised the issue of accuracy because it relied in the final sentence on the right to reputation. Now, in fact, when one looks at the issues which might arise, the balancing of the legitimate interests pursued by the Commission for Countering Extremism and the defendant, which is talked about in that final sentence, couldn't arise. And I'll take you to Article 6 itself to make that good. It's a piece of over-enthusiastic pleading. There's always a danger in pleading data protection claims that one anticipates what might be said by way of exceptions. Perhaps an illustration of the danger. Tab 56, please.
Of
Bundle 6. Page 1857. So the complaint is that the processing of the claimant's personal data was not lawful because it didn't none of the 61A to F applied. The final sentence of paragraph 20 of the particulars of claim is a reference to 61F, which reads, processing is necessary for the purpose of legitimate interest pursued by the controller or a third party, except where interests are overridden by the interests of fundamental rights and freedoms of the data subject. That's the balancing process. But then you'll see below that, point F of the first paragraph shall not apply to processing carried out by public authorities in the performance of their tasks. So the respondent has to rely upon one of 61A to E, none of which, in my submission, require an assessment of whether the data was accurate or not. The most obvious one, which might be relied upon in defence, is 61E. Processing is necessary for performance of a task carried out in the public interest on the exercise of official authority vested in the controller. That's the point on the claim in Article 6, under Article 6. And then the claim under GDPR Article 10, which is in paragraph 21 of the particulars of claim, complains that items personal data B to E are data related to criminal convictions or offences. Such processing is only lawful if one of the conditions within Article 10, the GDPR applies. Processing was not carried out under the proper control of official authority, nor is it authorised by UK or EU law, providing for appropriate safeguards for the rights and freedoms of the claimant. So it's no part of the pleaded case that the information was inaccurate or improperly infringed the Article 8 rights of the claimant. Ladies and Lords, I'm over my time estimate. Perhaps I can just turn around and see if there's anything more I ought to say. Unless I can help any of you further.
Thank you very much, Mr. Dean. Yes, Mr. Hudson.
My lady, my lords, it's our position.
Do you need to move over? Sorry, my lady, my Lord Justice Dingemans suggests that Mr. Hudson might need to move over a bit.
Sorry to be a pest, but if you literally go 2 feet to your left, I will see you, which may have advantages or disadvantages.
Do you want us to rise for a moment while you do that, or do you need to readjust your? Because you may need to.
I may need to, my lady. I'm very happy to.
No, I'm just concerned that you're going to need to move. We'll rise for a couple of minutes just to give you a chance to do it. Dingemans. We
I'm
do.
here.
Well,
Yes,
Lady,
Miss- yes, Miss-
I'm grateful for the time. I hope I'm in the right position. My lady, my lords, our position on the appeal, in summary, is that the learned judge engaged, as he had to, in a close, merits-based evaluative process, which required the striking of the balance between multiple factors. It was a multifactorial exercise. And he had to do that, the learned judge had to do that in order to determine whether in all the circumstances, and this probably qualifies as a unique case, but all the very unusual circumstances of this case, the appellant, or the claimant, was misusing or abusing the procedures of the High Court. We submit the learned judge reached the right decision, obviously. We submit the learned judge did not commit any errors of law or fact. He did not omit to take account of any material factors. He did not take into account any immaterial factors. And I'll explain why we say that. He didn't err in principle, and he was not plainly wrong, which seems to be, in reality, the substance of my learned friend's submissions. And we go as far as to say that the judge was plainly right and was correct that in the very unusual circumstances of this case, that it would be an abuse of the process of the court for the appellant to relitigate in the English High Court the question of his guilt, or in his case his innocence, of war crimes that were committed in 1971 in Bangladesh, and for which he's been convicted by the appropriate tribunal in Bangladesh. And we say the very unusual and the most relevant circumstances which I've referred to are these, and if I could set them out in summary, we would summarise them as follows. The relevant events had occurred in Bangladesh over 50 years ago, and we say that is important, and it is, we submit, important to focus and appreciate the fact that this took place in 1971, and it's not, the court isn't just concerned with the date of the conviction. The court is also rightly concerned with the date the events took place. Most, if not all, of the witnesses to the events in 1971 will now either be dead or untraceable, and many of the documents, if there were any, will inevitably have been lost. The appellant has not sought to appeal his conviction in Bangladesh. The words complained of appeared in a report of over 140 pages, but also only in a footnote in that report. And we say this is of particular importance. The words complained of referred to and were based on and relied on the conviction of the appellant for war crimes, and made clear that that was following a trial in absentia. There was limited hard copy publication, about 80 copies. There is no evidence as to the number of people who've read the report. As the judge observed, there are about just under 5,000 downloads, but as the judge observed, just because a long report like this has been downloaded, does not mean that many people read the footnote. The words complained of in the claim were removed in the online version before the claim was even issued. And we say importantly, and again unusually, there are numerous reports, not only of the conviction, but also reports published before the conviction as to the appellant's involvement in responsibility for war crimes committed in 1971. Importantly, if the appellant's claim in libel and data protection were allowed to proceed, the defendant would have to prove the truth of these allegations de novo because of the rule in Hollington and Hewthorne. And so the conviction, for what it's worth, and I accept that, but the conviction would not be admissible in the UK, in any UK proceedings or English proceedings. And we say that is an important factor, both under the heading of whether or not it is manifestly unfair for the proceedings to go ahead, and whether or not it would bring the administration of justice into disrepute in the minds of right-thinking people. We submit for all of those reasons the judge was right to conclude it would be an abusive process to allow the claim to continue in accordance with the principles set out in Hunter and all of the other authorities to which the court is being referred. But it was also right for the judge to conclude, as he did towards the end of his judgment, that on grounds of Jamil abuse, if he'd had to decide it on that basis, that the claim shouldn't proceed either. My lady, my lords, that is a summary of where we say the position is on the appeal. We say the judge was plainly right and got it right. The court is obviously very familiar with the test on an appeal of this nature, and we set it out in our skeleton argument. But we do remind the court that in reviewing the decision of the learned judge, the court will no doubt give considerable weight to the view the judge took in considering all of these many and varied factors. What I propose to do is deal with each of my learned friend's grounds in the sequence he's dealt well, in the sequence set out in his grounds of appeal. There are 8 grounds, and I propose to go through each one of those and make our submissions in relation to those, unless the court would prefer me to adopt a different course.
No, that sounds sensible.
I'm grateful. Could I deal then with ground 1? The first ground is, in essence, a submission that the judge made an error of law because he was not permitted, as a matter of law, to take into account a decision of a foreign court. That is ground 1 in its simplest terms. My learned friend has, during the course of his submission, somewhat shifted his position in that he now seeks or suggests that a statement of principle of that sort might go a bit too far, but that is the basis for his appeal. And we say that is simply wrong, and the authorities, we say, make it clear that a court, when considering an abusive process application, both generally and on the grounds of Hunter, can take into account, and must take into account, for what it's worth, the conviction or decision of a court from a different jurisdiction. And it does not even have to be a court, as the authorities make clear. it can be an arbitration tribunal, it can be varying different types of tribunal or bodies, but usually it will be a court of one sort or another. But it doesn't have to be within this jurisdiction. My learned friend is driven to say two things. One, well, a court can take into account a decision of a foreign court, but only if it is a court which ultimately, or of a country which ultimately has a facility or procedure to go to, for example, the European Court of Human Rights. We say that simply cannot be a principle.
Possibly New Zealand Privy Council.
New Zealand Privy Council, my lord, yes. We say that
it's a pretty wide definition of the jurisdiction for these purposes.
My lord, yes. And not at all a helpful one, because there is no basis of principle there to determine whether or not it is a court which, a decision of a court which the domestic court can take into account. But my learned friend's driven even further than that, because his position now is, well, he's not saying that the court can't take into account the decision of a foreign court when considering hunter abuse generally. His position is now, well, it can if it relates to unfairness, but can't if it relates to affront to administration of justice. And it's obvious why my learned friend is now adopting that position. But even that doesn't work for him for the same reasons, if I may say so. But also it's worse than that, because his administration of justice point, and I'll come on to this, is also dependent on his submission of law, which we say is wrong, that administration of justice is confined to the question of a party being vexed twice. So we say that the correct position as a matter of law is that a court, a domestic court, can strike out as an abusive process if the claim that's being brought, the claim that is in issue, is A, manifestly unfair to the party, in this case the defendant, or would otherwise bring the administration of justice into disrepute. That is the touchstone of this jurisdiction, this principle. There is nothing in there which limits consideration of those questions to domestic courts or foreign courts in some limited categories which my learned friend has tried to define. That inherent power is characterised by its flexibility, and to limit it in the way my learned friend tries to do simply is not supported by authority and wouldn't make sense. We contend that it is simply a factor which the court hearing the application for abuse has to take into account. And that is the appropriate way for it to be done. The court will take into account whether it's a foreign court, which jurisdiction it's in, the various other issues which we say the learned judge took into account. Now, to make good that submission, I can go through the various authorities, starting with Hunter, and seek to demonstrate, going through Hunter, right through to the House of Spring case, which my Lord Phillips referred to earlier, which is in the bundle, to make good the point that it is not confined to a domestic court. I realise that's going to take potentially a little bit of time, but if I can maybe the best course is to give some highlights, but I'm obviously entirely in the court's hands on this issue.
Well, we've seen the relevant passages.
Yes.
I think pick your best ones and
Great.
give references for the rest would be subject, obviously, to
Yes.
any. Unless
For my part, I wonder how much this point is really left, given the concessions that were made during the argument. And
Yes.
once you accept that Norway, New Zealand, but maybe not Australia, I'm not sure how much the authority is really going to help us resolve
Yes.
the question of whether that submission is right.
Yes. Well, obviously, there is a clear issue of law between us on this, and obviously we are slightly.
I do think you should develop it
I'm grateful
because it is relied on as a central plank of the appellant's case, and I think it's necessary for us to hear you
I'm grateful.
on the law
Yes.
in relation to this. But
I'll
as
try.
I say, bearing in mind we've been through the authorities
Yes.
in some detail, and you can pick passages by way of illustration and refer to others by reference.
My lady, I'm grateful for that indication, and I will endeavour to do that, of course. My learned friend took the court to Lord Diplock's speech in Hunter. He started with Nicol. I accept Nicol is in some ways foundational, but it was very much on its own facts, and it certainly can't be used as a guide.
Well, a lot of these cases are. That's the difficulty.
Yes,
isn't it?
is precisely, and that is of particular importance whenever the court is invited to consider any authority which is not dealing with the central point which arises in this case and the central point which arose in Hunter. And we suggest the central point is this. Is the claim being brought? Has it been initiated? We say that is an important consideration. Has it been initiated by the claimant, which of course it would have been if it's a claimant? And does it involve an attack on a criminal conviction? Now, the reason I emphasise that is because those were the facts in Hunter. It was that scenario which Lord Diplock said were unique, and it's particularly important because the question of whether or not a party has initiated the attack is a theme which runs through all of the authorities, and it is clear that it makes a significant difference to the outcome. So a lot of the cases my learned friend relies on are A, cases involving attacks on civil decisions, and B, the attack, the so-called collateral attack, is raised by way of a defence by a defendant in civil proceedings, which is wholly different from the scenario considered in Hunter and before this court. And that's what we do say one has to be very careful when looking at the various decisions my learned friend has relied on for statements of principle about whether or not this jurisdiction is limited to consideration of domestic courts. One has to be very careful to recognise that most of the cases it relies on are not concerned with the species or type of abuse which was present in Hunter and is present in this case. Because
but a collateral attack on a criminal conviction is only a type of collateral attack.
yes,
And it may be a particularly serious one because of the elevated burden standard of proof
yes,
in a criminal case. But of course, conversely, you don't have the problem of fairness of being twice vexed because party to the subsequent civil proceedings will probably not have been party to the criminal proceedings.
well, yes.
I'm not sure it's right to say it's in some way a distinct concept. It's part of the general concept of collateral attack.
Well, Lord, yes, but what does appear to be clear from the authorities is that criminal cases are recognised to be in a special category. One gets that clearly from the authorities. That criminal cases are recognised to be in a special category, and that collateral attacks on criminal cases which have been initiated by the defendant in the criminal case do fall into a category where, as a general rule of public policy, such claims should be struck out as abusive. And the authorities, I won't take the court to them, but the authorities we rely on in particular for that proposition, it can be seen in Lord Diplock's speech in Hunter, which the court's already been referred to. And it's pages 545A to B. And the page number I'm giving is a reference to the report itself. That is in the electronic bundles, tab 6, page 170. The proposition I made about initiating being the key, again, comes from Lord Diplock's speech in Hunter. And that's at page 542H of Hunter, page 167 of the electronic bundle. It's also is explained in part by Lord Diplock as to why there's a distinction between section 11 and section 13 in the Civil Evidence Act, which is dealt with in the same in passages of 543H to 544D. But then in Hall and Simons, Lord Brown Wilkinson says, and I can take the court to it at this stage or just read the proposition I'm relying on. In Hall and Simons, Lord Brown Wilkinson says at page 685C, and that is tab 18, page 533 of the electronic bundle, where the latest civil action must, in order to succeed, establish that a subsisting conviction is wrong. In the overwhelming majority of cases, to permit the action to continue would bring the administration of justice into disrepute, save in truly exceptional circumstances, the only permissible challenge to a criminal conviction is by way of appeal. Now, also in Hall and Simons, Lord Hope said in a dissenting judgment, I accept that all cases which can be treated as amounting to a collateral challenge to a subsisting conviction will be dismissed or struck out. Now, I don't rely on these for the proposition that a case which involves a collateral attack on a criminal conviction, whether domestic or foreign, must be struck out. Of course I don't. But we do rely on them for the proposition that they are in a particular category where the public policy, or the starting point, is that cases such as these will not be allowed to proceed because the appropriate way to challenge a criminal conviction, certainly in the domestic setting, is by way of an appeal. And we say, for these purposes, it doesn't make any difference whether it's a domestic or a foreign conviction.
But it's certainly the case that the cases you referred to so far are not considering foreign convictions, are they? They're very firmly in the domestic context.
My lord, I accept that. And I accept we are reasoning by analogy that the rationale and the policy arguments which apply to lead to that public policy, we say apply equally to foreign convictions. I accept they may not apply as strongly in certain contexts. And my learned friend's challenge, however, is that his position on the appeal, or ground one of the appeal, is that a foreign conviction cannot be taken into account for these purposes, which is, we say, obviously wrong. And we say that disposes of ground one of his appeal, because the judge was plainly entitled to take it into account. Now, as I say, we even where it's a domestic conviction, the law, we accept the law is not that it must automatically be struck out as an abusive process. The general public policy is that it usually will be, other than, as Lord Brown Wilkins said, only in exceptional, truly exceptional circumstances will it not be.
Well, if evidence emerged that conviction was procured in circumstances which were grossly unfair, for example, it subsequently transpires that a party had been bribed or there had been corruption or whatever, then plainly that wouldn't then be the case, would it? It wouldn't be so straightforward.
My Lord, with respect, I entirely agree with that. It would not be so straightforward. But it would be a factor which the court would take into account, one of the many factors. But equally, our position is, as it was before the learned judge, it does not follow simply because there may have been unfairness during the trial in any particular case.
Because you could appeal.
Or one can appeal.
Domestically.
And the public policy is made clear by the decision in Smith and Linskills and in Hall and Simons, is that criminal convictions should be challenged within the criminal justice system. And we say wherever that is, whichever is the appropriate tribunal. It just so happens in this case that the appropriate tribunal was in Bangladesh. So our overarching point is that the abuse of process principle and the Hunter form of that is characterised by flexibility. There are no hard edge rules. There are no fixed categories, and it's unhelpful, as the cases make clear. It's unhelpful to try and impose fixed categories, but that is precisely what my learned friend is trying to do. And that's clear from Lord Diplock's speech in Hunter, right from the opening paragraph, where Lord Diplock says, and my learned friend did read this out, it would be most unwise to say anything to be taken as limiting to fixed categories. And therefore my learned friend's first ground just simply fails. That's also made clear in Smith and Linskills that there should not be fixed categories. Lord Diplock was not doing that either in the opening paragraph, where Lord Diplock set out the overarching principle, and equally where Lord Diplock set out the summarised the position on what is described as Hunter abuse. Again, Lord Diplock was not there fixing the categories, and we submit, nor was Lord Diplock there setting out, as one would in a statute, the necessary ingredients of abuse. That's perhaps appropriate if I could take the court to the particular paragraph I have in mind. So it's in Hunter, which is tab 6. The overarching paragraph I've referred to is at page 536, C to D of the report, page 161 of the electronic bundle. The court's been taken to that already. So that is no fixed categories, the overarching principle as to abuse of process. That and that is clearly what is subsequently described, for example, in Kamoka as the touchstone of this inherent jurisdiction, of this power, this salutary power to strike it as abuse. And then Lord Diplock, at page 541H of the report, page 166 of the electronic bundle, at the bottom of that page describes collateral attack on a final decision of a court competent jurisdiction may take a variety of forms, which reinforces the point I've already made. It is not surprising that no reported case can be found in which the facts present a precise parallel with those of the instant case. We say that is, we agree that's not surprising, that's what's happening in this case. Then at the foot of that page at H, this is the first case to be reported in which the final decision against which it is sought to initiate a collateral attack by means of a civil action has been a final decision in a criminal jurisdiction. And then if I could invite the court to then turn to page 544. Again, statements of principle. And then at 545, Lord Diplock sets out the general rule of public policy at 545A to B. Use of civil actions to initiate a collateral attacks on final decisions against the intended plaintiff by criminal courts of competent jurisdiction should be treated as an abusive process of the court. So we submit it's entirely clear from that Lord Diplock's words are not to be read as a statute setting out necessary ingredients which have to be satisfied as a matter of law or fact before the court can strike out. And the same approach can be seen, we submit, in the case of Smith and Linscall's, which is at tab 8. Could I invite the court to turn to tab 8, and it's page 769 of the report, page 186 of the electronic bundle. And we rely on this, I will come to this in more detail, but we rely on this to deal with my learned friend's submission about full opportunity. But for present purposes, again, we say what this makes clear and reinforces is that the use of the words full opportunity by Lord Diplock in Hunter, again, are not to be read as a statute, as a hurdle which must be overcome or necessary ingredients which must be satisfied before the court can strike out for an abusive process. Then and that's why we submit at 769 C to F, Sir Thomas Bingham, as he then was, makes it clear that this is a rule and a principle which requires a flexible approach, and it will inevitably depend on all of the circumstances. Now, the clearest way we submit to make good the point about it not applying solely to domestic jurisdictions is the case referred to by my Lord Phillips, the House of Spring Gardens and Way case. That is at tab 62. Although that wasn't in the bundle before Sir Andrew Nicol, it is referred to in the case of Johnson and Gore Wood, which was in the bundle. It's tab 62, and if I could just take the court to that briefly.
Tab 62.
Tab 62, it begins at page 1915.
Not sure I've got a tab 62.
Sorry?
I haven't got a tab 62.
Sorry, my lady. I'd understood the authorities bundles had been updated.
He came in last night.
Should I just simply give
Just give the reference.
references for my lady,
Yeah.
and if we can find a further copy in the meantime? I'm afraid I've only got electronic copies, but well, my lady, may I just give references for now?
Yes.
Thank you. The
I
matters-
I can find it. So if you want to refer to passages, please do so. Bylaws have a copy of the authority.
I'm grateful. Well, I know my learned friend referred to House of Spring Gardens. I'm not sure he summarised the facts, so I can take those from the head note if that would assist. The claimants in an action in Ireland against the 3 defendants for misuse of confidential information and breach of copyright obtained judgment for a very large amount of damages. Following dismissal of their appeal, of the defendant's appeal by the Supreme Court, the first and second defendants brought an action in Ireland to set aside the judgment, alleging that it was obtained by fraud. The action was dismissed. On the plaintiff's claim against all 3 defendants in respect of the sum awarded by the Irish court, the judge, in the absence of any new evidence, held that the defendants were stopped from alleging in the present proceedings that the judgment in question was obtained by fraud. There was an appeal by the 3rd defendant, and that to the Court of Appeal, that appeal was dismissed on the basis that the judge had correctly held that the first and second defendants were stopped, and that the 3rd defendant, even though he did not join in the Irish proceedings to set it aside, was well aware of those proceedings and was privy to them, and therefore, in the absence of new evidence affecting the issue of fraud, the 3rd defendant was similarly stopped. Further, it was held that even if the judgment did not create an estoppel, it was an abuse of the process of the court and contrary to justice and public policy for the issue of fraud to be relitigated in the English court after the issue had been tried and decided by the Irish court. And so we say, as is clear from the judgment given by Lord Justice Stuart Smith, that there is no prohibition in that case from taking into account on an abuse of process application a decision of a court in a foreign jurisdiction, albeit not as far away as Bangladesh. Of course, I accept that. It's perhaps worth noting at page 250 of the report, 1924 of the electronic bundle, at H, and this is in the context of the discussion about estoppel, Lord Justice Stuart Smith says this: a foreign judgment that is final and conclusive on its merits and is not impeachable on the ground of fraud or other grounds that are not material is conclusive as to any matter thereby adjudicated upon and cannot be impeached for any error of law, any error of fact or law. See Dicey and Morris, page 460, Rule 42. And then there is discussion about whether a different approach should apply as between English and foreign judgments when it comes to allegations of fraud. But then at 251H, Lord Justice Stuart Smith says this: the judge did not find it necessary to consider the question of abuse of process, and it is perhaps unnecessary for me to do so either. But I have no doubt whatever that even if the judgment of Mr. Justice Egan in Ireland did not create an estoppel, it would be an abuse of process for the Waits to relitigate the very same issue in the English courts upon which they failed in Ireland, not least because they themselves chose that forum which was the natural form in which to challenge the judgment of Mr. Justice Costello. And then at 254F, the Lord Justice Stuart Smith makes the point that the categories of abuse of process are not closed, And then finally, simply on the facts of that case, Lord Justice Stuart Smith at 255 B to D said the question is whether it would be in the interest of justice and public policy to allow the issue of fraud to be litigated again in this court, it having been tried and determined by Mr. Justice Egan in Ireland. In my judgment, it would not. Indeed, I think it would be a travesty of justice. Not only would the plaintiffs be required to relitigate matters which have twice been extensively investigated and decided in their favour in the natural forum, and I emphasise those words, but it would run the risk of inconsistent verdicts being reached, not only as between the English and Irish courts, but as between the defendants themselves. And then finally, at D, public policy requires that there should be an end of litigation and that a litigant should not be vexed more than once in the same cause.
And that's after just citing Hunter, Lord Diplock's opening passage.
My Lord, yes. Yes. So, there's then, which won't have reached my lady's bundle, unfortunately, but at 63 there's the Owens Bank in the Twirl case. That's at tab 63. And I'll simply give the references for present purposes, if I may.
What is the name of the case?
Owens Bank against a Twirl, I'm probably mispronouncing that, E-T-O-I-L-E. It's 1995, One Weekly Law Reports 45. Now, the facts of that were quite complicated, but the various decisions included a decision of the Commercial Court of Paris, and also a claim in St Vincent and the Grenadines, and it was still held in that case that it was an abusive process. In the context of deciding abusive process was a much shorter answer to the various complicated issues about estoppel and trying to reopen judgments for fraud in English and foreign jurisdictions. And that can be seen from page 51 of the judgment. I'll simply go to that. 51A to D. Lord Templeman. Starting, these are interesting, important arguments. Those were the arguments about finality of foreign judgments and whether they could be impeached for fraud. Their lordships do not, however, find it necessary to deal with them because there is a much shorter answer to this appeal. Every court of justice has an inherent power to prevent misuse of its process, whether by a plaintiff or a defendant. See Hunter. This was the alternative ground on which the Court of Appeal decided in the plaintiff's favour in House of Spring Gardens against Waite. There is nothing in the authorities which precludes a party from obtaining summary judgment or an order striking out a pleading on the grounds of abusive process where a fraud is alleged. It is axiomatic that where fraud is alleged, full particulars should be given. Where allegations of fraud have been made and determined abroad, summary judgment or striking out in subsequent proceedings are appropriate remedies in the absence of plausible evidence disclosing at least a prima facie case of fraud. No strict rule can be laid down. In every case, the court must decide whether justice requires the further investigation of alleged fraud or requires that the plaintiff, having obtained a foreign judgment, shall no longer be frustrated in the enforcing of that judgment. And then concluding at G, the defence of fraud which they put forward is an abusive process and should be struck out. And so, my lady, my lords, we say that is the answer, one of the many answers to my learned friend's ground one. The only case that my learned friend can point to which which suggests there is some other approach is the Standard Chartered Bank case at first instance. We submit that that does not assist my learned friend in the light of the authorities I've already referred to, also in the light of the judgment or the decision of the Court of Appeal in that case, which does not adopt the approach of Mr. Justice Flow as he then was in that case. But perhaps more importantly, the observations relied on by my learned friend in Standard Chartered Bank were clearly overtook by Mr. Justice Flow. But we say critically, it's important to recognise that it was not a case concerned with the issue of abuse of process or by a collateral attack on a criminal conviction. The facts in Standard Chartered Bank are horrendously complicated, as was recognised by the Court of Appeal in paying tribute to Mr. Justice Flow's description of them at first instance. They are horrendously complicated, but what is clear is that they are a million miles away from the facts in this case, or the facts in Hunter, where the court is dealing with a prior defendant or defendant criminal initiating civil proceedings which are an attack on the conviction. And then it's further undermined by the judgment of, as he then became Lord Justice Flow in Komoka, which is at tab 44 of the bundle, and that's Komoka against the Security Service. And if I could just simply give the court various references. But what we take from that is it is clear from Komoka that Lord Justice Flow saw the abusive process principle derived from Hunter as very much needing a flexible approach. That paragraph, I'll simply go through the references. Paragraph 48 of the report, that attacks on criminal convictions were in a special category. And perhaps most importantly for present purposes, at paragraph 58, which is page 1354 of the electronic bundle, page 2661 of the report. It was made clear not only the flexibility, but that the principle was not limited to collateral attacks on courts of competent jurisdiction. That's clear from paragraph 58, and then Lord Justice Flow's summary of the relevant principles from 59 to 62 make clear the potential breadth of the power, the salutary power, which we submit is inconsistent with a reading of the learned judge's decision in Standard Chartered Bank as being confined to, certainly in a case like this, being confined to domestic convictions and not foreign convictions. It's also worth noting that paragraph 75 of Lord Justice Flowe's judgment sets out what I've described as the touchstone of this principle.
It's worth noting that Owens Bank and Etoile and a related case called Owens Bank and Bracco were both doubted by the Supreme Court in Takar and Gracefield developments.
Well, I'm not familiar with that.
That's in relation to the issue of setting aside a previous judgment on the ground of fraud.
Yes. Yes, my lord. That what was described as the interesting question doesn't, to us anyway, appear to touch on the issue of whether or not, or the breadth of the abusive process principle. It might be that it wouldn't be needed in a case if the position was different on impeaching a judgment for purposes of fraud. But we'll certainly look at that overnight, but it seems to us that doesn't undermine the question of whether or not abusive process is confined to domestic courts.
Right, if the dicta of Lord Templeman was not applied. Anyway, might look at that further.
If I may, we'll look at that overnight. I'm very grateful. Could I say something very briefly about the sections 11 and section 13 of the Civil Evidence Act? Simply to say, they do not, we submit, have the effect for which my learned friend contends, that because Parliament has decided that section 13 and section 11 should be confined to UK judgments, that it therefore follows that the abusive process jurisdiction cannot be exercised in relation to foreign judgments. We submit that the two run in parallel, and there is nothing to indicate, and we'll explain why we say this further in our argument, there's nothing to indicate that the approach set out by section 13 removes the power of the court to take into consideration decisions of foreign courts. And the Law Reform Committee report, albeit very interesting, does not contradict that position. May I move on to ground two? So for all of those reasons, we say ground one just simply fails as a matter of law. The judge was perfectly and rightly entitled to take into account the foreign conviction. Ground two is my learned friend's contention that the appellant must, and it's his word, must have had a full opportunity of contesting the conviction in Bangladesh, and with the consequence that if the appellant did not have a full opportunity of contesting, then the abuse jurisdiction could not be exercised. And again, this is an issue of law between us. Our position is, as I've already said in relation to ground one, the error the appellant makes here is to seek to read Lord Diplock's judgment in Hunter as a statute. Rather than recognise and accept that this is a flexible doctrine. And one of the factors the court must take into account is the opportunity the defendant had in the criminal proceedings to contest those. We accept the court that is a relevant consideration as part of the multifactorial exercise which has to be carried out. But there is not a definition of full opportunity as if it were a statute by which the court can measure whether or not the appellant did have a full opportunity or did not have a full opportunity, with the result that determined whether or not the court can strike out on the basis of abuse of process. Moreover, it's important, we say, to recognise what was meant by the words full opportunity, albeit, of course, I say it is not to be read as a statute, but there is an indication in Smith and Linskill's as to what Lord Diplock must have meant by full opportunity. And we say that is an important matter to take into account, which the judge clearly did take into account. It does not mean, in summary, our position is, it does not mean that the criminal proceedings had to be flawless or perfect, or that there could be no suggestion of error or unfairness in the criminal proceedings. And that's clear from Smith and Linskill's, which is at tab 8. And if I can invite the court to look at tab 8, please. And the question of full opportunity is dealt with at page 769 of the report, electronic page 186. And the argument had been made by counsel for Mr. Smith that the defendant in the criminal proceedings, the claimant in the negligence proceedings, had not enjoyed a full opportunity to contest the decision in the Crown Court, this is at G, because the negligence of the defendant had prevented him deploying the full case which he would wish to have deployed. And Sir Thomas Bingham said at H, this argument in our judgment is founded on a misunderstanding of what Lord Diplock meant. It is plain from his speech that Lord Diplock was giving his ruling with reference to both civil and criminal cases. It is evident in civil cases that a party may lack an opportunity to resist a hostile claim, as for example where judgment is entered against him on the ground of procedural default. So that's where the defendant in a civil claim would have lacked any opportunity to contest or resist a hostile claim, or may lack a full opportunity as when summary judgment is given against him. So the distinction being drawn there is between cases in which there is no consideration of the merits in the context of a civil case, no consideration of the merits of the claim in issue, because either it has been, judgment has been entered because of procedural default, for example, judgment in default of defence, where there's no opportunity, or there's been summary judgment. So lacking a full opportunity would apply where there'd been summary judgment, but not where there hadn't been summary judgment. And then to deal with that in the criminal context, Sir Thomas Bingham went on at 769A, thus the soundness or otherwise of his criminal conviction is an issue at the heart of these proceedings. Sorry, I've gone to the top of that page. over at 770, we understand Lord Diplock to have been intending to preserve a party's right to make a collateral attack on a decision made against him in such circumstances. So that is, we submit, albeit one's not to read these as statutory words, that's the distinction being drawn by the Court of Appeal in Smith and Linscores in the context of what amounts to a full opportunity. Now that...
There are a couple of things to be said about this. Plainly, both Hunter and Smith and Linscores are looking only at English proceedings.
Yes.
And what they are saying is that it's quite difficult to allow a party to say, I didn't have a full opportunity in criminal proceedings where he's represented by counsel, can
Yes.
give instructions, etc., and also can appeal.
Yes.
If he wasn't properly represented. Do you accept that there must be a very different approach by the court when it is looking at an allegation of abuse in relation to foreign proceedings, where there is at least raised a question mark as to whether those proceedings were basically fair given their procedural structure and rules and potential penalty, and b, the specific matters which happened in relation to the claimant's participation.
Yes. Well, Lord, I accept those are matters which the court ought to take into account when deciding the question of abuse of process.
And
So-
do you accept that in this case, on your strikeout, and given what we've seen and the judge saw, that the only proper approach you could have was to proceed on the basis that the proceedings were grossly unfair to the claimant?
Well, Lord, our position before the learned judge was that even if the proceedings...
Well, do you accept that was the basis upon which you should proceed?
The basis we submit the basis on which he ought to proceed and as we read the judgment did proceed, was to recognise that there had been strong criticisms by the appellant and others as to the procedural defects.
Well, let me phrase it another way.
Yeah.
Did you below, or do you on this appeal, mount a positive case that these proceedings were other than a gross miscarriage of justice against the appellant?
No, my lord, no. I don't advance a positive case that the proceedings were not or were fair.
So in other words, on a strikeout
Yes.
application, surely the basis upon which the judge should have proceeded, and it seems that he probably did, and that we must proceed, was that the Bangladesh ITC proceedings were a gross miscarriage of justice.
Well, we have what the judge says at paragraph 56. Perhaps we can look at that.
Yes. Yes, I'm grateful, my lady. It's tab 8, C78. Mr. Hudson submitted that the present proceedings would be an abuse even if all that the claimant said about the ICT proceedings was correct. In other words, the defendant's strikeout did not depend on the finding that the ICT proceedings had been fair and impartial. The Secretary of State did not advance a positive case that they were unfair or partial, but she did submit that the proceedings would be an abuse of the process of the court even if all that the defendant said about them was correct.
Yes,
So
that's why I asked you the question I did.
Yes, but my lord, the reason I'm hesitating, of course I accept on a summary judgment application, the defendants, the respondents, well, depends.
You assume the facts in favour of the respondent to the application.
My lord, yes.
Yes.
I'm grateful. I don't necessarily accept that that applies in exactly the same way on an abusive process, an application to strike out on an abusive process application. And I can't say, it's not it wouldn't be appropriate for me to say it's accepted that the proceedings in Bangladesh were unfair or involved a gross miscarriage of justice. But
Well, do you say that the appellant had a full opportunity to defend himself?
well, yes, I do say in the context of what is meant by that, as clarified in Smith and Linskill's, I say yes, he did. But I emphasise, as I've said already, that it is not to be read as a statute. And so we suggest what the court has to do in these situations, it's not a tick box exercise or a reading of statute. The court has to take into account all of the factors. And on this, the judge had to take into account the complaints, the allegations made about the ICT, the proceedings in the ICT, and even on the basis that those complaints were justified, the judge had to decide, well, even on the basis that they're justified, what is the right decision? Is this manifestly unfair to the defendant, and/or would it bring the administration of justice?
Well, I'm just trying to understand what you say was his opportunity to defend himself. Never mind applies the statute. I think we all have a quite good feel for what is a fair proceeding against a defendant. What was his opportunity to defend himself?
Well, he could have participated. He could have participated in the criminal proceedings.
In person?
Yes, he could. Now, I accept.
Well, we wouldn't have extradited him to Bangladesh.
No, we wouldn't have extradited him.
Because he would have been subject to death penalty.
Yes, I accept that. But as the judge observed, the appellant was faced with a dilemma in this situation. Did he return and contest the proceedings with the potential consequences? Or did he do what in fact he did, was essentially to ignore those proceedings and not participate in them? That was a dilemma for the appellant. But nonetheless, he still had an opportunity to take part. And the reality is...
Well, he could have taken part through his counsel.
Yes.
Had they communicated with him, which they didn't.
Well, Lord,
that can't be an opportunity to defend yourself.
Well, I think we've probably reached the end of this particular debate. So perhaps we can move on.
Well, lady, I'm grateful. That's our position on why my learned friends ground 2, which is the full opportunities ground, does not succeed, because we say in summary that the learned judge took into account all of the relevant factors and reached a conclusion in the light of all of those factors, including working on the assumption that there was unfairness in the proceedings. But despite that, the learned judge reached the conclusion that it was still an abusive process. And that does link in with my learned friend's ground, which is essentially the decision was plainly wrong. But it's important, I say at this point, that our position, as it was before the judge, is that this is not a binary issue. So it's not simply a question of saying if the proceedings, the criminal proceedings were or may have been unfair, however one wants to describe it, or potentially involved a gross miscarriage of justice. Even if a court reached that conclusion, it does not follow that it is not manifestly unfair to the defendant to have these liable proceedings brought against them, and or it doesn't bring the administration of justice into disrepute among right-thinking people. So we do say it's not a binary question. That's why I come back to the point about it's not a tick box. Obviously, it's not a tick box exercise. It's not simply a question of persuading the judge the appellant did have a full opportunity or didn't, and therefore it follows necessarily from that conclusion whether or not it can amount to an abuse. Because the touchstone isn't just full opportunity. The touchstone is, as set out at the beginning of Lord Diplott's speech in Hunter and as identified in the later cases, the touchstone is manifest unfairness to the defendant in this case, and bringing the administration of justice into disrepute. And that can still happen, and we say it is the case in this instance, even if the trial had been unfair or was unfair. And that also applies to the question it's on ground 2, my learned friend's other position on ground 2, which was the judge wrongly took into account the appellant's failure to appeal. Against the decision in the Bangladesh in the ICT. It is, we suggest, important to look at precisely what the judge said and decided in relation to that issue. It was, it's dealt with at tab 83. Sorry, tab 8, paragraph 83. A3 5 to 7, 6 to 7, the judge deals with it. Seven had. Seems to me that he's trying to have the best of both worlds by remaining outside Bangladesh but challenging his conviction. In my view, that course is not open to him. The proper forum to decide whether the trial was so tainted by unfairness that the conviction cannot stand is the appellate court in Bangladesh. Had the claimant pursued that course and succeeded in having the conviction quashed, the merits of the defendant's argument would have been entirely different, of course. And then, sorry, I should have taken the court's first to the end of paragraph 6. Accept Mr. Hudson's submission that the proper course of the claimant, if it is important to him to challenge the conviction, is or was to appeal within the Bangladeshi criminal process. It may be that an opportunity he had to do this is now past, but that is not material to whether the present proceedings are an impermissible method of collateral attack on the conviction, which in my view they are. So the judge took into account, and we say he was right to do so, took into account the possibility of an appeal, but it was just one of several factors that the judge had to take into account in deciding whether or not it was nonetheless an abusive process for the claimant to bring these proceedings, which involved, as the judge found, a collateral attack on the criminal conviction.
Well, my lady will bear with me. I would like to ask one question about that. What would the ground of appeal be?
Well, it seems to us that the appellant contends the proceedings were unfair for various reasons. What hasn't been demonstrated by the appellant, either before this court or before Sir Andrew Nicol, is he didn't attempt to appeal. It's not said that had he, although my learned friend makes this submission, but there's nothing in the evidence to support the proposition that an appeal on the grounds of the unfairness of his trial would have inevitably or could not have succeeded. But the danger, if I may, of starting to inquiring into those issues is that the court has to carry out this essentially a form of satellite litigation into the procedural defects or otherwise of the ICT, what may or may not have been available to the appellant before the ICT, without a proper basis on which to do that. And that is why our position was, before Sir Andrew Nicol, that even if there is this unfairness, it's still, because it's not a binary question, it does not lead to the conclusion that necessarily it is not an abusive process to bring these libel proceedings against the defendant. Could I then turn to ground 3? Ground 3 is that, again, as a matter of law, that the fairness limb of Hunter is confined to a party being vexed twice. So it seems to be Mullane and Friends' position that when considering whether or not it was manifestly unfair to the defendant, the judge could not take that into account. In fact, it could not be manifestly unfair to the defendant because the defendant was not being vexed twice because the defendant was not a party to the criminal proceedings. That's, as we understand it, that's Mullane and Friends' position as a matter of law. Our response to that is that, similar to the submissions I've already made in relation to ground 1, this language is not to be read as a statute. It is clear from Lord Diplock's speech and from the way in which it's been applied in subsequent cases that manifest unfairness is not confined to situations in which the parties are essentially the same. Particularly because in many cases a party would be able to rely on some form of estoppel in that situation, and it's also clear from the authorities that the courts have and can and have found there is manifest unfairness to a party, even when that party was not a party to the previous proceedings. And that is, we say, entirely consistent with the flexibility that is required of this jurisdiction. The flexibility that's required of this jurisdiction and the close merits-based analysis of the facts which the court must engage in deciding whether or not there is manifest unfairness and whether or not there's been abuse. We submit that is particularly clear from the case of Secretary of State for Trade and Industry in Bairstow, and that is at tab 20. The passage, I'll read the head note. The former managing director of a company brought wrongful dismissal proceedings against the company. Dismissing the claim, the judge found that the director had been guilty of grave misconduct and neglect in the performance of his duty. The director's appeal against that decision was dismissed. The Secretary of State for Trade and Industry subsequently applied under Section 8 of the Company Directors Disqualification Act 1986 for a disqualification order against the director on the ground that he was unfit to be concerned in the management of a company. The Secretary of State wished to rely on the findings made in the wrongful dismissal proceedings, and at a pre-trial review the judge held the parties were not entitled to challenge but bound by those findings. The director appealed, and the appeal was allowed. Now, the passage I particularly rely on for these purposes is at paragraph 38. Decision of Sir Andrew Nicol, Vice Chancellor. That is page 655 of the electronic bundle and page 16. At 38, the following propositions are set out, 38 onwards. A collateral attack on an earlier decision of a court of competent jurisdiction may be, but is not necessarily, an abuse of process of the court. B, if the earlier decision is that of a court exercising criminal jurisdiction, then because of the terms of section 11 to 13, 1113 the Civil Evidence Act 1968, the conviction will be conclusive in the case of later defamation proceedings, but will constitute prima facie evidence only in the case of other civil proceedings. C, if the earlier decision is that of a court exercising a civil jurisdiction, then it is binding on the parties to that action and their privies in any later civil proceedings. If the parties to the later civil proceeding, D, if the parties to the later civil proceedings were not parties to or privies of those who are parties to the earlier proceedings, then it will only be an abuse of process of the court to challenge the factual findings and conclusions of the judge or jury in the earlier action. If one, it would be manifestly unfair to a party to the later proceedings that the same issue should be relitigated, or two, to permit such relitigation would bring the administration of justice into disrepute. And so we take from that Roman numeral 1, referring to manifestly unfair to a party, can include, even in the context of a criminal case, someone who was not party to the previous proceedings. And that principle set out in Bairstow was expressly adopted by the Court of Appeal in the Wilson case, which is at tab 43 for the court's note. Tab 43, page 1355 of the electronic bundle, and specifically at paragraph 48.4. So again, my learned friends attempts to confine the ambit of this particular aspect of the power, we say is simply wrong as a matter of law. And that the learned judge was right to conclude that he could take into account unfairness to the defendant in this case, even though obviously this defendant was not party to the criminal proceedings and wasn't on that basis, in my learned friend's language, being vexed twice. My learned friend relies on the speech of Lord Hoffman in Hall and Simons. We say that doesn't assist him, and but perhaps the shortest way I can deal with this is to refer the court to the speech of Lord Brown Wilkinson in Hall and Simons, which is at tab 18. I may have referred the court to this already, but it's tab 18. So the reference is, it's page 685, A to D, that I rely on. Page 533 of of the electronic bundle, page 685 of the report A to D. And we say it's clear from that when Lord Brown-Wilkinson was discussing manifest unfairness, that could apply equally to criminal proceedings, which must necessarily or usually mean will not involve the same party being vexed twice. So we say that, again, this ground simply as a matter of law does not work, and the judge was perfectly entitled to take into account any unfairness or manifest unfairness which he concluded there was in relation to the defendant. And lady, my lords, I propose to turn to ground 4, which is it seems to us to be my learned friend's position that the judgment was plainly wrong, which is a high test to satisfy. As I said at the outset, we submit that it can't be demonstrated the judge was plainly wrong. In fact, not surprisingly, we say he was plainly right to reach the conclusion he did. And we say that for the following reasons, some of which I've already referred to at the outset. Whatever the flaws may have been in the ICT proceedings, it remains that the appellant was convicted in the Bangladesh ICT of very serious criminal offences of war crimes relating to 1971, of events which took place in December 1971. The reference to that, the words complained of, as I said at the outset, are contained in a footnote. We say that is a matter of some significance. Not only are they contained in a footnote, but they are a reference to the conviction and to the trial, to the appellant being tried in absentia. And what we say, what the appellant is trying to do, it is clear, we submit, he is trying, through the side wind of a footnote in a long report, he is trying to establish in a public judgment by a court in this jurisdiction his innocence of very serious crimes which took place 50 years ago. Despite the fact he's been found guilty by the tribunal specifically set up to deal with those crimes in the most appropriate location and jurisdiction to consider and determine them. And the fact that it's not simply in a footnote, but the fact that the words complained of rely on and refer to his trial, we say is of considerable significance. Because this is not a gratuitous statement made without the context of the appellant having been convicted that he was responsible for war crimes or the murder of 18 intellectuals in 1971. It is referable to and based on the decision of the ICT. We say that makes a very significant difference to the question the court had to decide on the question of abuse of process. And that, we say, is the beginnings of why the appellant's libel claim against the Secretary of State is an abuse. But it is made significantly worse by the features identified by Sir Andrew Nicol as to the very real challenges and difficulties that will be faced by the defendant in having to defend these allegations. And say, if it was in the context of a gratuitous allegation that he'd been guilty, that he'd committed these offences, that's one thing. But where it's in the context of a reference to his trial and trial in absentia, which is made clear, we say that's a very different thing, because it's not simply making these allegations in a vacuum, which might, as my learned friend said earlier, well, that's their lookout, and if you do that, then you're going to have to defend it and you're going to have to deal with it. That may well be a fair criticism if these allegations had been made in a vacuum and without the context, the critical context, we say, of the appellant having been convicted in Bangladesh.
In the light of the decision of Mrs. Justice Tipples on meaning,
Yes.
where does this point land?
Well, we say that it's a perfectly appropriate matter for the court to take into account when deciding abuse, that the circumstances in which it was published, even in the context of Mrs. Justice Tipples' ruling on meaning, the court can still take into account the circumstances of publication, the nature of publication, the extent of publication, all of those matters. Now, I accept Mrs. Justice Tipples determined, when deciding the question of meaning, that meaning could not be considered in the context of someone clicking on the hyperlink. That was the submission which had been made before Mrs. Justice Tipples, and that was rejected. So I accept for these purposes we are confined to the footnote. I can't make the submission, well, it's not just the footnote, but it's also if you click on what you see, and that reduces the seriousness or the sting of the meaning. I don't make that submission. I confine the submission to simply the fact that this is a footnote, but the footnote does refer to being convicted found guilty following a trial in absentia. And I say that does make a significant difference to the question of deciding, it's not determinative, the question of deciding whether or not it is manifestly unfair to the defendant to be faced with libel proceedings in that context. But it's not simply the fact that it's in a footnote and it's done in that way. It's also, which has to be considered, in the context of the publicity which has gone on for decades, both before and following the appellant's conviction in the ICT, that he was responsible for, involved in the murder of these 18 intellectuals in December 1971. And we say the judge was entitled to take that into account when considering whether or not it was manifestly unfair to the defendant to have these libel proceedings brought against her, and or would bring the administration of justice into disrepute in the minds of right-thinking people. But it goes further than that, we say, because the fact that these crimes took place over 50 years ago inevitably makes it even more difficult to establish the truth of them, as the judge recognised, we say rightly recognised, because of the extreme passage of time. These are in reality historic allegations now. It does make a difference that they are in Bangladesh. And so it is because of that combination of those factors and all the difficulties which would be faced in such a context of defending these libel proceedings, that the judge was right to conclude it would be manifestly unfair. And we do submit that right-thinking people in this situation would think this is an entirely inappropriate matter to be litigated by a court, a libel court in London, as to whether or not the appellant had committed these crimes 50 years ago after he'd been found guilty of them by the appropriate tribunal. And right-thinking people would think this is wholly inappropriate and wrong for an English libel court to be used as a way of trying to exonerate the appellant after having been found guilty of these matters. Not just because of all the practical problems we identified and the judge referred to, but also because in these proceedings, in the libel proceedings, the burden of proof is not on the claimant the appellant to establish his innocence, as the court is very, very familiar with. And even in relation to his data protection claim, which he pursues on grounds of inaccuracy, even on that, he would only simply have to prove on the balance of probabilities that he wasn't guilty of these very serious matters or it was inaccurate, run to the criminal standard, which is obviously the more appropriate standard in such matters. And so, and it seems to us the right-thinking person would take the view, well, there may have been defects. Of course there may well have been defects in the ICT proceedings, but that it does not follow because of those defects that the right course is for this issue to be tried in a libel court in London. Because of the very real risk, we say, of on the basis of the decision of the ICT, of undeserved vindication for the appellant. But in addition, as the learned judge identified, where would these proceedings get the appellant? He doesn't seek an injunction. The very substantial amount of documentation and publicity that's out there, which says he is guilty of these offences, not least the Channel 4 Dispatches programme, which is still available online, which sets out in considerable detail the allegations as to of guilt and his involvement in these.
What was the date that was broadcast?
We believe it was 1995. My Lord Justice Phillips identified an error in.
No, not 1996.
We think it was 95. It's 95 in our chronology.
We saw the letter, didn't we, which came after it?
Yes, which was I think May 96. So everything we've had so far is all been 1995. It's not easy to identify from the from the program itself if one looks on YouTube, it doesn't, as far as I can see over the short adjournment, it wasn't clear when it was broadcast from that, although we'll have another look this evening. But we'll double check, but our understanding is it's 95. Certainly that's the chronology, and that's the evidence in the witness statements says it was 1995. But that is still available. It goes into considerable detail, including showing interviews with witnesses, including eyewitnesses at the time, as to the appellant's involvement in responsibility for these war crimes back in December 1971. There are all the press reports. There's the judgment itself, the ICT judgment itself, which is available and can be read, which goes into very considerable detail as to the findings as to why the appellant was guilty. And of course I accept my learned friend's observation that many of the articles that are out there also include the claimant's denials, but not all of them do. But it still doesn't counter the fact that there will be very substantial material out there which continues to publicise the fact that the appellant is accused of and has been found guilty of these very serious war crimes. So again, in that, and that's not just a Jamil point, we say that is an important point when considering whether or not, A, it's manifestly unfair, but whether or not that would bring the administration of justice into disrepute. Because we submit, the right-thinking person would rightly consider that in that context and in all of those circumstances, it is bizarre that the appellant can bring libel proceedings with all the time and expense and cost involved in that to try and achieve some form of vindication in an English libel court based on a reference in a footnote to his conviction following a trial in absentia. My lady, that's all I wanted to say on the plainly wrong. Obviously I rely on all the observations made by the learned judge in his judgment as to why we submit he was right, certainly not plainly wrong. Is this a convenient time before I move on to the next ground?
I haven't noticed the time. Right, all right, we'll sit again. And how are we doing for the...
Well, I believe my learned friend's giving me till 12:15 tomorrow, and then so that's just short of 2 hours, and then my learned friend had planned to reply from 12:15 to 1. If the court would like us to finish before 1 o'clock, then we would endeavour to do that, but if we've got to...
Well, we have the morning. I'm
Go
sure neither you nor Mr. Dean will waste time.
No.
So if you finish earlier, good. If not, then we're here and we'll listen to your submissions.
Yeah. Well, I'll review it overnight, my lady, and if I can speed up a bit, I will endeavour to do so.
Good. All right. Sit again tomorrow at 10:30. All right.